Abandonment and divorce in Illinois. Sometimes a spouse doesn't ask for a divorce. They simply vanish, leaving the other partner to rebuild their life without closure or legal resolution. In Illinois, abandonment is no longer a legal grounds for divorce, a significant change that came into effect in 2016 when the state eliminated fault-based divorce entirely. Before 2016, Illinois recognized a long list of fault grounds, including willful desertion for 1 year, unexplained absence, and 2 years of separation, all of which were essentially forms of abandonment. Today, every Illinois divorce proceeds under the single ground of irreconcilable differences, and simply filing for divorce is considered sufficient proof of that breakdown. While abandonment is no longer a grounds for divorce, it remains a powerful and consequential concept that shapes property, parenting, and support decisions throughout the case. The most pressing question in any abandonment situation is whether the missing spouse can actually be found and legally served with divorce papers. If the abandoning spouse can be located and served personally, the court gains full personal jurisdiction, allowing it to enter orders for child support, maintenance, and division of marital property. If the abandoning spouse cannot be found, the court is limited to what is called in Rem jurisdiction, meaning it can only rule on the marriage itself, custody, and non-marital property, not financial support or asset division. When it comes to maintenance, Illinois courts consider the needs of each party, and a spouse who has been self-sufficient during a long abandonment may find that maintenance is unlikely to be awarded. The logic is straightforward. If both spouses have demonstrated they can live independently without financial support from each other, a judge has little basis for ordering alimony. Abandonment has some of its most dramatic effects when children are involved, because an Illinois court that finds a parent has abandoned the family will award sole custody to the remaining parent. Illinois law under 750 ILCS 6516 states that if a parent abandons the other, that other parent is entitled to custody of their minor children, a protection built directly into the statute. A parent who disappeared will face an extremely high bar to reestablish parenting time, since Illinois courts weigh each parent's willingness and ability to maintain a close, consistent relationship with a child. Illinois courts can also reduce parenting time due to abandonment under 750 ILCS 5600 10 and will almost always require reintegration therapy before an absent parent can resume meaningful contact. On the property side, a spouse who has been abandoned for more than 1 year can petition an Illinois court to authorize the management, control, and sale of jointly held assets to support the family. Alternatively, if the abandoning spouse has been gone long enough, the remaining spouse may file a petition for a presumption of death, which opens a separate legal pathway for resolving the estate. Navigating these layered legal issues, service, jurisdiction, parenting time, maintenance, and property, requires the guidance of a skilled family law attorney who understands how Illinois courts handle abandonment cases. Russell, the 500th, Knight is a Chicago family lawyer who has been admitted to practice in Illinois since 2006 and has helped clients face exactly these challenges, from tracking down absent spouses to protecting parental rights. Contact the law office of Russell the 500th. Knight at 773, 334, 6311, located at 1165 North Clark Street, #700, Chicago, Illinois 60610, United States, to schedule a consultation and take the first step toward resolving your Illinois divorce.